Workers' compensation is a very complicated system. A lot of people get injured at work and don't understand the positives and the negatives that go into workers' comp, especially here in California. Today, we're going to dive into the topic of utilization reviews and as well as
Independent
medical review. Explain. Thank you, Bilal. Joining me today is
Bilal Kassem. I'm the co-founder and president of Pacific Workers.
And I'm your host, Carmen Ramirez. Thank you for joining us once again on Work Comp Talk podcast. If you haven't subscribed yet, make sure you do so now. If you haven't shared this podcast with someone who's currently going through a workers' comp case, I would highly suggest to do that. There's very, very great information that you can find in this podcast. And if there's something you want us to dive into that we haven't touched yet, by all means, please shoot us a message or a comment, and we'll be more than happy to touch on that subject. Today's subject is a little tongue twister. It seems very complicated, but it's a niche within medical treatments, right? Utilization reviews and the independent medical reviews and all of that. There's just it's like a spider web. There's so many ways to go about it.
Yeah, and I feel like it's one of the most under-discussed and most complex, frustrating part of a workers' comp case for an injured worker.
Now, when you say it's under-discussed, why?
No one really talks about the process in and of itself and why it's so bad and how to navigate it. You know, people are often just told no. You want back surgery? No. You want medication? No. You want to see this doctor? No. And that's the end of it. And when the injured worker says, well, why not? The answer is, oh, that's just what the system is.
Wow.
Yeah, and I feel like people don't really have a good understanding of what it means to go through the medical treatment process in workers' comp. And it's not as simple as just, say, going to your own doctor. And I think people really need to understand why it's so complex and how it benefits them. And quite frankly, more often than not, how it hurts them. It's not easy. And as a lawyer, it's hard for me to explain things in great detail to my clients as often as I feel they need to understand. And so I felt like this is a good opportunity to really dive in deep and discuss what it means to go through utilization review and what the independent medical review process is. Right. For utilization review, that's a process by which the insurance company has the ability to either deny liability for medical treatment or accept liability or modify it, meaning that they only authorize a part of the requested medical treatment. So, for example, if you sawed your arm off and you went to your doctor, they'd probably do everything you need to. They'd do MRIs, diagnostics, they would do surgery, all this stuff, and they'd send you on your way, granted probably with a very large hospital bill, but they would do what you need the same day, no questions asked. In work comp, it's a bit different. You know, if you go in and you say, hey, I have back pain, and your doctor wants to do an MRI, they have to request authorization from the insurance company first. They can't just do it right away. And oftentimes that can mean delays. For example, when a doctor wants to request authorization, the insurance company has up to 5 business days to respond. And if they request additional information, 14 calendar days. Meanwhile, if you don't have your medication, if you're in excruciating pain, you need treatment, whatever the case may be, you even may need surgery, you have to wait.
Shit. What do you do when you have all the pain?
You suffer, unfortunately. But, you know, I have clients a lot where they have serious conditions and they say, well, you know, the pharmacy won't refill the prescription. My doctor wrote the prescription 2 days ago. I'm out of the meds. I need it now. Unfortunately, the insurance company has up to 5 business days to review and authorize it. And even then, they may not even authorize it.
And how often times does that actually happen where they take those 5 days into accountability and just wait for the 5th day just because?
Honestly, I think they just wait to the 5th day automatically. I can't tell you how many. I never see a utilization review decision come back early, right? It's always like the 5th day. That's just how it works. I think they have their internal system set up and they have ways to go about reviewing things. So it's always like clockwork on the dot, right? And the injured worker's sitting there suffering, unfortunately.
That sucks. Like, there's no way around it. Like, you have to wait for that approval.
Yeah.
Even on medication, if it's necessary. Like, I'm in excruciating pain that I will probably go back to the hospital and my pain or my injury will even get worse again if I don't treat it as these 5 days could be a long wait.
Yeah, and there's different types of utilization reviews. There's retrospective review, there's prospective review, which means, you know, either before or after the treatment. The issue is with medical treatment, all the doctors, they're not going to give you the treatment you need and then seek authorization on the back end.
Right.
And it's because the insurance company will turn around and deny it and say, oh, well, the treatment wasn't authorized. And then the doctors out the money for the medical equipment, the surgeon's fees, whatever the case may be, and they're left with it. And so the doctors are stuck between a rock and a hard place in the sense that they want to help you, but just their hands are tied too.
Right. Are there doctors that still just help regardless because they see that it's necessary?
Sometimes.
Do they get in trouble for that? Like,
they don't get in trouble. They just don't get paid.
that sucks.
And look, there's some good doctors, and they'll go out on a limb to do things to try and advocate for their patients and, you know, be a great resource and help patients get what they need to recover from their injury. And there's others that'll just kind of throw their hands up, and it's, you know, some do, some don't. I can't blame them. You know, it's just the system, unfortunately, they're stuck in. But the utilization review process, I would say most times it's a denial process, right? More often than not, I see requested treatment either denied or, you know, severely restricted. You know, a doctor may request 12 sessions of physical therapy, they get 5. You know, they want to do 3 months of medication, they get 1.
So what happens in those cases? Like when the doctor recommends more and they only do X amount, are you shit out of luck again?
Sometimes. There's a rule that stands that if a utilization review decision has denied a certain type of medical treatment, that denial stands for up to 12 months unless there's a material change in circumstance. So for example, if your doctor wanted to do a surgery and the reason the request was denied was because you didn't have an MRI, but then your doctor requests an MRI that's authorized and then the doctor resubmits the request and it's before 12 months, that's okay to resubmit. Otherwise, if nothing's changed, the denial stands. If the denial's there and it's the first time or it's a modification, mainly partly authorizing the care, then you can actually try to submit that through what's called IMR or independent medical review, which is a third-party review process that injured workers can use to contest a denial in a workers' comp case.
This is insane. So we talked about all of the, I guess you can say, the cons about a UR, a utilization review. What is something good about it?
You know, in some cases, it may protect the injured worker. There may be a scenario where a doctor maybe doesn't have the patient's best interest at heart. I don't know if you saw, but, you know, a while back, I think this was pre-COVID, there was this hospital down in Los Angeles, Pacific Hospital, and there was a doctor that was indicted by the attorney down there for fraudulent billing practices and illegal referrals for kickbacks. And this doctor was referring patients for back surgeries that the patients probably didn't really need. Maybe they did, maybe they didn't. I can't speak to that too much. But, you know, there's doctors out there clearly motivated by money and not for patients' best interests. And they may want to do various types of treatments that may not be beneficial to an injured worker. And I guess the one benefit I could see to utilization review is that it's a checks and balances system and that it does in some sense help regulate requests for treatment that may not actually help the injured worker and may be prescribed for other reasons.
I mean, it's a good pro, but it's not like...
Yeah, in practice, I'm like, that's 0.2%. Like,
but
you know,
I mean,
the utilization review cases.
Right? I mean, it's a thing that people have this idea. Like, you go to the dentist, and you know the dentist is going to try to rack up all of your annual
You went for a
abilities.
cleaning, and now you need replacement teeth.
You need a root canal. You need this. And you probably don't even need it, but it's just this, I guess, conception that we have that doctors do that.
Yeah.
So in this case, if they can get away with it, I mean, I guess it is a good thing.
And I think that's at heart what utilization review really is designed for and is used for in practice by insurance companies to limit costs. You know, if I told the insurance company, hey, you can give this injured worker everything they want, whether it's medication, surgery, benefits, and it's not going to cost you a dime. Of course, the insurance company's like, I don't give a shit. You know, it's $0, fine. This person needs help. Give them whatever they want. The more I start to tally up costs and say, hey, this is going to cost 10 grand, this is 20 grand, this is 30 grand, the more they're like, hey, pump the brakes, right?
Right.
And I think utilization review, under the guise of being a tool to ensure that the injured worker is just getting treatment that's medically necessary and appropriate, is really like, hey, how much money can we save with this process? And we used to be able to use doctors and fight over utilization review denials and such. But when IMR was created, that changed the game. We used to be able to go to court, for example, to challenge utilization review decisions if they were defective or we wanted to fight over doctors' opinions. But now this IMR process is even worse off.
Oh, gosh. I thought there was going to be some positivity coming into that.
No. So IMR was created somewhat recently, like 7 years ago or so. And it was this process that was then used to it's basically an appeals process. And there's doctors that contract with the state. We submit appeals for utilization review denials to the doctors. The doctors review the medical records that are relevant and the request to determine whether or not the utilization review decision should be overturned. That's like a 95% denial rate, so I don't put much stock in that.
Okay.
It is. I went to a conference in San Diego a while back, and they, at the time, had said the uphold rate, which means the supporting the UR denial, was something like 89% or something ridiculous. I've had a few big wins. I've had some surgery denials overturned, and my clients loved it. And I was really thankful. I've had a couple medications and urgent stuff flipped over by IMR, which has been a great win for the client. I usually tell my clients, look, it's a really shitty process. It's all we have in the system. Don't bank on this. You know, try to go back and challenge the utilization review decision on other grounds. Like the example I gave about the MRI, like have your doctor look at the UR denial and try and check off the things that were listed as a basis for denial and resubmit the request and try and fight it on that end rather than just, resting on your laurels and praying that IMR comes back and works a miracle for you and flips things around, because more often than not, it doesn't.
When does the IMR come into play when the UR is just not? Like, is there a specific timeline?
Yeah, so IMR will only address substantive issues with utilization review, meaning if utilization review was improper, like the medical records weren't reviewed or it was late or some other reason, IMR won't touch that. So IMR only looks at the substantive reason the case, or the medical treatment, was denied. Once IMR is invoked, essentially, it's something you have to process within 35 days of the denial from utilization review. Utilization review IMR has 35 days to review a request for authorization. There's a mandatory time frame, although in practice, there's no time limits. We've tried to fight over this before, and there's nothing out there that says that if they don't do it in time, it's automatically authorized, right? So usually utilization review is on time. Usually IMR is on time. When utilization review is late, we can fight that and get things authorized. But for IMR, if it's late, there's not a lot we can do about that. Then if you get an IMR decision and ultimately the IMR decision is not something you're happy with, you can technically appeal that to the Workers' Comp Appeals Board, although the grounds are limited. It's like fraud or the decision was based on an erroneous fact. Like IMR said no surgery because your right leg doesn't need it, but it's like a back surgery request, something like that. That would be grounds to have the judge order IMR to review the case again. And I actually just had that in a case. The patient had an MRI that was done, which wasn't reviewed. And IMR based their denial on the fact that the MRI wasn't presented. And it clearly was. We had fax confirmations, we had letters, everyone admitted it was there. And so I actually had to go to court to have the judge order IMR to redo the request for authorization.
That's insane. That's like adding extra work and making shit even longer.
Well, if you're a patient, you're sitting there and you need surgery, you got like a torn rotator cuff and you can't use your arm or something, and you're being told I have to wait, 10, 20, 30, 60 days for something that may or may not happen. That's frustrating. It's scary. You don't know what to do.
Besides the frustrating part, waiting on surgery sometimes can make the injury get worse. That happened to my dad. My dad had an injury where he cut his hand and the tendons and the nerves and everything, and it was just insane. The doctor who actually performed the surgery at Stanford Hospital had told him, had this been approved sooner, you would have had more mobility on your hand. Your hand would have been able to stretch out more. Because of the tendons, they started shrinking, and because they had made a quick fix just to kind of close the injury while all these decisions were being made, his hand started healing, so now there was scar tissue, and it's just, he's got half of his hand tied because had this situation unfolded faster, he would have had a little bit more flexibility in his hand, or even being able to hold something. Because right now at this point, his hand is like, he can't really use it.
Yeah, we see that all the time.
It sucks.
I had one client, she had fractured her leg and she was walking around on it for like 4 weeks before anything happened. And it was similar. The doctor's like, well, it's healing, it's messed up. This is kind of how it's going to be. Or you see, a really common one is a torn pectoral muscle. It retracts. And if you wait too long, that's it. You can't reattach it. And a lot of orthopedic surgeons have touched on that. And we've had cases like that. And yeah, it's just, unfortunately, the patient's paying for it. And there's no recourse for that. It's just the system.
Do you think that there's ever going to be change?
There's a lot of people lobbying for it. Unfortunately, the battles we fight in workers' comp are difficult. There's a huge insurance lobby in California in particular. And it's oftentimes horse trading. We get little victories in workers' comp as far as the legislature is concerned, but it's because we traded something else.
Yeah.
In 2013, we got higher permanent disability rates, but we traded permanent disability for psych, sleep, and sexual dysfunction secondary to physical injuries. There's all these trade-offs. So I don't see the system changing. I think a lot of insurance companies in California would love to see workers' comp go single payer and see workers' comp be eliminated completely. There's a big fight right now to get rid of cumulative trauma cases, just in general, the whole idea of cumulative trauma being an injury. So there's a lot of movement, but in the wrong direction, I think. Us as voices for the injured worker have smaller voices than the insurance company, unfortunately.
Yeah. So IMRs, utilization reviews can be a worker's worst nightmare.
It always is. It always
sucks.
is. And it's something we explain time and time again to our clients. And every time it's heartbreaking because we have to sit there and, tell someone who's in extreme pain or in need of, treatment, medication, surgery, that they're not going to get it. And trying to understand their frustration and be there for them and console them without any real map or guide for recourse. Like, we can't tell them it's going to be okay and we'll get you what you need. There's tools that we can use to shop around and fight and do stuff like that, but we're still in this closed universe. And we have limited resources that we can use to step out of that universe. So, for utilization review and IMR, some of the biggest battles we fight are really just making sure everything's done procedurally. Like the IMR decisions, the utilization review decisions, they all have to have certain things and be done in certain times by certain people and communicated at certain places. And really, we can use those little tricks and loopholes to try and invalidate denials and things like that.
Now, this is all great for those that have representation. What happens to the people that don't have an attorney? How will they even know about the IMRs? Will they know about this?
Yeah, so when your doctor requests authorization, the utilization review denial should be communicated to everyone. The utilization review decision itself is required to come with the IMR paperwork. The IMR paperwork itself can be complex and you may not understand it. And if you don't fill it out right, you don't send it in a certain amount of time, you waive your right to it.
Damn.
So, it is there. The insurance companies are required to provide it to you. As a lawyer, I can tell you how many times IMR paperwork mysteriously doesn't show up, or even utilization review decisions aren't communicated to us as lawyers. And it just happens to be on something crazy like, home health services or back surgery, something really expensive. And I'm almost guaranteeing they're like manipulating the system. They're not sending it to us on purpose because they're hoping we won't notice, enough time will go by.
And then it's no longer act. Oh.
Yeah. And there's been cases where we had this on a back surgery case. There was supposedly a denial. It was never communicated to us. I had filed a motion for penalties and sanctions. I had set the case for trial. And then at like the 11th hour, like months later when we're getting ready, we're literally at trial. The defense attorney mysteriously comes up with a copy of the denial, and it's like conveniently, dated on time, like months prior, but no one had a copy of this up until we got to this point in the fight. So it's like, did you really have this, or is this, some BS that you concocted with your client because you're about to get hit hard, right? And they produced that. And the judge's perspective is, well, it was produced. They have this proof of service that said it was sent to you. So,
what am I to do?
Yeah, what am I to do? I'm not going to sanction them or hold them accountable. And so there's so many cases like that where we say we don't get copies of things, the doctors say they never received it, and the insurance company manufactures, a denial or something after the fact. I can't prove that, but it's just so convenient.
Right, of course, it's a quick fix for them.
Exactly, and then they know that the insurance company is not going to be held liable by the judges because the judges can't really do much if they have this supposed proof in their hand.
Evidence. Oh, yeah. Gosh, this is the reason why we're saying it's a very complicated system.
Yeah.
Workers' comp, it's not a walk in the park. And it's definitely something that is going to change the future, if not the life of many injured workers. Some don't
Yeah.
even get back to what their life used to be prior to injury. So it's
Yeah.
important to seek out guidance. Just ask for help, ask questions. I think that's the best thing someone can do as an injured worker.
Yeah, navigating the process is not easy, especially medical treatment denials and whatnot. And you can go to information and assistance at the Work Comp Appeals Board. I don't know that they're going to give you the level of attention and detail that you need that you would get from having a lawyer do this
So
stuff
just
for
throw
you.
a book. Here, read that. It's on section whatever. Figure
Well,
it
and it
out.
might be a one-off, you know, and then
Who
what
knows?
about the next time? What about the next time, you
Yeah.
know? And there's information and assistance officers at the court, and they're there to help people who are self-represented, but they're helping a lot of people.
It's not
right?
just one. Yeah.
I'd kind of analogize it to like a public defender.
Yeah, that's what I was
Like-
gonna say. I was like, kind of reminds me of like a public defender when you would go to court.
Yeah, in some sense. Like, what are you going to get a better chance of, you know, getting off of your murder trial or whatever it is? You know, are you going to go with your public defender, or are you going to, you know, go get the attorney that costs $1,000 an hour and is like practiced, done criminal trials, and you're their like only client, right? It's a different result. And so I think most people are better served having a lawyer, and doing things like fighting appeals, IMR applications, all that stuff. That's not an extra charge. You know, that's just something that's included within the contingency fee. That's usually 15%. So like, you're not paying extra for all this stuff.
Yeah, it's
just
part of.
Yeah, it's just you're getting all this stuff as part of the representation.
And more, because I'm pretty sure this is just the utilization review and the IMR. Like, this is just like a little niche of what workers' comp actually is. So
Yeah.
it's a win-win situation.
Yeah.
The money doesn't come out of your pocket. It doesn't, like, you don't have to cough up the money and just be like, okay, here's the money that goes on your part. It all gets paid through the insurance company.
Yeah.
So it's a win-win situation, I think.
Yeah, definitely. And look, we may not get your treatment, you know, overturned and authorized, but I'll do a damn good job of explaining why it wasn't, you know, and I'll make sure that, you know, all my clients know what's going on in their case. And quite frankly, it's, you know, one of the harder things to do is have these conversations with clients, because I understand how, from an outsider's perspective, how crappy the system is.
Yeah.
But we do our best.
That's good to know. Well, if you guys need any more information, feel free to reach out to Pacific Workers on website, pacificworkers.com. You can also find them everywhere on social media. You can find them through Work Comp Talk podcast as well. We want to thank you for listening. We'll catch you guys on the next episode. Thank you.